I resigned from the U.S. Attorney's Office to run, and so prior to that, I was with the Department of Justice. I just finished an assignment in Pakistan and the Philippines, where I set up prosecution offices. So I resigned to run in January, and now I've been a full-time candidate with a little blip because I prosecuted the rancher case down south, so in Santa Cruz County.
Oh, wow.
Yeah.
Okay, so before I get into just the questions that I'm supposed to hit with you and the other candidates, let's just go through your background, or just tell me a little bit about you and your career.
Sure. I'm a product of a Marine Corps family, and I grew up in North Carolina, and then when my parents retired, they retired to Montana, where I spent some of my time on a ranch, not Yellowstone. And then I got a scholarship to Oregon, and undergrad at Oregon. Went to law school at Lewis and Clark to become an environmental lawyer, and then I'm a triplet, and so one of my brothers was sick here in Tucson, so I dropped everything and moved to Tucson. While I was here in Tucson, I went to get an MBA at Thunderbird up in Phoenix, and I started prosecuting at Santa Cruz County years and years ago. And so my very first career prosecution job was at Santa Cruz County, and then I quickly moved to the Attorney General's office, and then from the Attorney General's office to the U.S. Attorney's office, which most people, that's the capstone of their career, because that is where everyone wants to end up, because you do some of the biggest cases in the nation. I was lucky that that's not the end of my career, because the Department of Justice selected me for an assignment in Pakistan, where I helped set up prosecution offices. So I've been gone for nearly 2.5 years, setting up offices in Pakistan, working on gender-based violence cases, terrorism finance, and those sort of things. So that's me in a nutshell. And people always talk about the career part, but I've been a community activist. I was on Tucson Clean and Beautiful board. I was on the Tucson Museum of Art board. I've been a Special Olympic coach. I've been a Habitat Humanity volunteer. I've been a mock trial coach. And so I've just been anyway, so if you haven't heard of me, it's because I've been busy working and doing other things. So
That's like a 20-page resume, man.
it's a lengthy resume, yes. So.
Yeah.
Anyway.
Okay. Anything else you wanted to mention about your background or anything before I go to like the certain bullet points I have?
Well, it's never usually told, because I usually don't like to bring it up because I like to keep privacy. But I'm married to my best friend Kelly for 19 years, and she's a professor at U of A. And I wouldn't be here but for that.
Is this Kelly?
That's not Kelly.
No. Okay.
No, I don't think she.
Know. Sorry.
No, but she would never. Yeah, no. Kelly is more of an introvert, so she doesn't usually come out for, for the such. This is Isabel, the campaign manager.
Hi, sorry. And then how many kids do you guys have?
0 kids.
0 kids. Okay.
Yeah.
So just you and Kelly, best friend, has helped you, and she's an introvert because you're definitely not.
Well, I'm more of an introvert, a little bit more, but not as, I'm on the continuum. I'm more of an extrovert on the continuum. Definitely not the party goer guy, but I'm definitely a little bit more extroverted than she is. So obviously, if I'm a prosecutor, I've got to be able to stand up in front of people and make a case and so that sort of thing. So I've got to be somewhat outgoing, but I'm not the guy that goes out Friday night, no.
Okay. Okay, good to know. All right. So first thing that we would like to address is a lot of our viewers are critical of the low bonds. So let's talk bonds. What's your opinion on them? We know the current county attorney has been criticized for having low bonds on and getting out of jail. So what would you like to see done, I guess?
I think the best way for the viewers to understand the cash bail bond system is, my view is to think of 3 silos. You have people who shouldn't get bond, who are dangerous and violent. Those people should never get a bond. They stay in custody pending the outcome of their trial or however they're adjudicated. No bond for dangerous and violence. Then we have the people who are in custody who should not be, because there's nonviolent misdemeanors. And so there's no need for them to be in custody, because you want them back supporting their families, and you can summons them in or bring them in for the court hearing. There's no threat to the community. There's no threat to failure to appear. So those people should be out of custody, period. So non-dangerous misdemeanor cases out on their own recognizance or third-party release or some other pretrial conditions of release. Then you have that small little group of white-collar crime criminals who are wealthy and who've stolen a lot of money from people. Those kind of people you want to have a bond on. They have to pay into the system because we don't know if they're going to flee on you because they got the resources to flee. Or you have people who have multiple failures to appear. They have demonstrated in the past they don't appear for court. So they're going to have to buy into the system a little bit to show that they're committed to whatever the outcome of their case is. So for 99% of the cases, it's no bond, both cases. No bond for violent, dangerous offenders, but also no bond for, because there's no bond, I don't want them in custody, period. The non-violent, non-dangerous individuals, I don't want them in custody either. So they have work, they have families, they need to support their kids, they need to do these things as their case is pending. So,
would you make any changes to what's currently happening?
well, we have, unfortunately, the current county attorney made promises on, what she can and can't do, and so what
There's a new thing if you go to.
Hey guys.
Okay, do an interview.
So sorry.
no,
Would you make any changes currently?
Well, I would instruct my attorneys to seek, we were going to seek release conditions which are consistent with my theory. So if you've got a non-dangerous, non-violent offender being held in custody pending the outcome of their case, I'm going to instruct my attorneys to agree with release conditions. I'm going to instruct my attorneys to do so. And if there's an issue with the initial appearance judge, we'll appeal it to the Superior Court judge. And so there's things you can do to make your plan, to effectuate your plan. The current county attorney's office, the current county attorney has no idea how to do this because she's never been a prosecutor. She's never ran a prosecution office. She never supervised prosecutors. She's never been in this role before. Her entire experience has been on the defense side. So.
Okay, next topic. Let's talk death penalty. Where you stand on it. Obviously, it's off the table, and our current prosecutor does not believe in it. Where do you stand?
I also, death to the death penalty. There is, in my administration, there'd be no seeking the death penalty in any case.
You want to elaborate on that?
Well, two reasons. One, I think is meted out unfairly and arbitrarily, and so that's number one. The most important reason is meted out arbitrarily. Number two is it's expensive for the county. I mean, the amount of money we spend seeking the death penalty, where I could focus on other homicides, other sexual assaults, other burglaries, other robberies, the amount of money and resources we devote to one case. And the third reason, which no one really talks about too, is the victim closure. Some of those cases last years and years and years, and the victim doesn't get closure. So if I get a guilty verdict and they sentence to prison without parole, I protect the community, and that is a just punishment for an individual who deserves that.
Okay, let's go to your stance on sentences fitting the crimes, and what's your philosophy for that?
100% they should fit the crime. I mean, we're not talking about here overcharging, and we're not talking about over-sentencing. Neither are we talking about undercharging and under-sentencing. We have a discretion as a prosecutor, and you have to be doing this for 17 years. The whole goal of having a county attorney with experience is prosecuting, because we learn through the small cases, the medium cases, the more severe cases, and then your ultimate severe cases of homicides and sex assault. So you learn how to adjudicate these cases justly, and there's a fair treatment among defendants across the spectrum. If you don't have that experience, then you don't know how to adjudicate these cases fairly. So we definitely don't want to overcharge. We definitely don't want to over-sentence. We definitely don't want to do the other way either, because we have victims involved in a lot of these cases. If you're talking about cases where there's drug issues, drug possession and stuff, we want people with drug treatment. We want diversion. We want diversion on steroids. We want to make sure people get the wraparound service they need. However, if you commit a crime against a victim, we want some accountability. We want some rehabilitation, but we need some accountability. But definitely no overcharging, no oversentencing.
Do you think that's happening now?
I think it's the other way. I think there's not enough accountability. I think there was a case with two juveniles who were 17 years old who beat up a kid and ran over him and dragged him behind the vehicle, and they both got probation. And so you're looking at a situation where you have an ineffective county attorney who doesn't give justice to the victims. There's two parties to these equations when you're talking about a violent offense. You're talking about a defendant, but you're also talking about a victim. The victims need to have their voices heard too. So if you ignore that because you're so focused on these defendants, you're avoiding the other piece of this equation. And you have to make justice is there has to be accountability before you can get rehabilitation. And so when you commit a heinous crime, you have to have some consequences.
Okay, let's talk about sheriff saying, the current jail is dilapidated, they need more space and upgrades, new technology. Where's your stance on getting a new jail or upgrades or any of that?
The most important part is we definitely want all inmates to be treated safely and fairly and in a comfortable living environment, because we don't want liability to the county. We also want workers to be we don't want them to have overcrowding issues with the jail or have poor work conditions. So we're cognizant. If I'm county attorney, I'm not trying to dodge the question, but I have to give advice both to the Board of Supervisors and represent the Sheriff's Department. So I'm not going to weigh in, but I do agree with the county administrator that we need a new study. We need a further study on what's going on. I know a Blue Ribbon Commission was completed, and I think the result was we need additional studies to figure out what we're going to go forward on. I endorse that. More studies, more empirical data is important. But for me, everyone needs to be treated fairly and safely in those jails, including the inmates and the workers.
What is your stance or your philosophy on the Arizona State Bar's investigations and outcomes that they've been having? Do you think anything needs to be done with that? Do you think the State Bar is running properly?
Oh, I can't. I couldn't give you an intelligent comment on that. I do know that our county attorney currently is in a diversion program, which should be a concern for every voter, because as prosecutors, we should be beyond reproach. We should be way beyond that line, far away from that line of questioning the ethics of your top prosecutor. Because when you're a defendant or a victim, you need to have some surety that your prosecutor is beyond reproach. And now we've got a county attorney who messed with a case, the Lewis Taylor case, which is pending trial in federal court. And so you've got yourself a current county attorney, which is typically unheard of to have under the diversion program of the State Bar, which is charged with making sure that we comply with the ethics and professionalism of our guild, if you will. So we need to make sure. So I can't comment if the State Bar is doing a good job or not. I mean, they're doing the job that they're measuring the competency and the ethics and the professionalism of our attorneys, and I assume they're doing a good job. I mean, I couldn't intelligently.
What do you think about that investigation? Elaborate on that. Your thoughts on the diversion program with the current.
I think it's an automatic disqualifier. When you're in a diversion, we have. Can I give you the analogy? This is not. I don't want to even equate the severity of the two, but we currently have a candidate for president who is a convicted felon, who we are thinking about, should he be president of the United States? We have a county attorney who's in a diversion program, and we're considering that she should continue on with her job. It should be an automatic disqualification for her to be in that position. I've been doing this for 17 years. Not once have I come close to that line. Not once has a defendant or a victim or a law enforcement agency or anyone else said, Mr. Jette, we have found proof that you've done X, Y, and Z and you're in violation of these rules. That should tell you everything about the two candidates. And so I think that should be an automatic. But what's more troubling than the diversion program is a lack of ownership. We ask defendants to show contrition, to take responsibility for their conduct. We do plea deals, we do trials, we do all the things before they step up for sentencing. A lot of defendants say, yes, I did wrong, I apologize, judge, go easy on me, whatever the mitigation is, they explain their story. We have a county attorney who minimizes this diversion. Instead of saying, I did wrong, I move on, I was too passionate, or whatever the reason is why you got involved in the Lewis Taylor case, whatever that reason is, take ownership of it, apologize, and move on. The inability for that person to do that, so it's two issues. One, diversion should be a disqualification, but number two is, where's my ownership? I grew up in a Marine Corps household, and that one of the things that my dad taught me is taking responsibility. Regardless of how painful it is, you take responsibility, because that is how you learn and move on and become a better person, attorney, prosecutor, whatever it is.